Okay, thank you, David. So that was a great recap of the status of where we are both on the financial and the objection side. What I'd like to do now is take a quick review of some of the Tax Court of Canada cases dealing with financial issues to highlight some of the opportunities, but also some of the pitfalls that are being faced by claimants and also by tax practitioners. The first case is very interesting. It was a company called Oldcastle, and the facts of the case are that we had an employee, Mr. Castengay, who is a very successful developer. He held personally 70 patents in the concrete architectural area. He had sold his company, him and his brother had sold his company for approximately $100 million to a very large company. And now he was an employee of that company who received a base salary of $400,000 and an additional variable amount based on the sales of the company. And the issue in the case became whether the variable amount was a commission, bonus, or a remuneration based on profits. And if so, what effects would that have on the claim for Mr. Castengay's salary? The relevant legislation goes across sections 37, 127 sub 9, and the regulations itself. In particular, it focuses on the definition of salary and wages in 248 sub 1 of the Act, which basically says everything's in sections 5 to 8 of the Act. Okay, so Income Tax Act 248 sub 1 definitions talk about salary and wages, talk about it being the income from office or employment under Division B, Part 1, including all fees received. So sounds very technical, but if we go to Division B, Subdivision A, we basically understand that there's some basic rules on inclusion, taxable benefits, and some deductions. Okay? So there's your base office from income or employment, your salary and wages, including gratuities, and additional amounts of taxable benefits. So what I found as a practitioner is this whole issue becomes very confusing. What types of salary and wages are eligible? What are the rules on bonuses? And what are the rules on something called specified employees? So the first issue becomes, what in fact is a specified employee? And a specified employee is any employee who owns 10% or more of any class of stock of the corporation, or anyone related to them by blood marriage or adoption. So effectively, most owners of small companies are specified employees. And in fact, what happens is there's various limits that are anticipated or affected by this. There's a limit of 5 times yearly maximum pensionable earnings on the amount that the specified employee can claim for wages, and a further limit of 2.5 times that amount for something called the salary base that determines the proxy overhead or an overhead allocation. Okay? So what that means effectively is for 2016, 2017, 5 times YMPE is roughly $275,000, meaning that an owner, manager, or a specified employee who receives salary or wages for SR&ED could earn credits on the first $275,000, and after that amount, they would still get a deduction for those expenses, but they would no longer earn tax credits. Now, in the case of a non-specified employee, there really are no limits. There's really different effects on whether bonuses are in or out at all for purposes of calculating wages. In both cases, for a specified employee, bonuses are not included or remuneration based on profits. However, for a non-specified employee, such as Mr. Castengay in this case, they would be in for the wages, but in fact, they would come out again for purpose of calculating the overhead expenses. So again, once this structure is understood, this is what leads to most of the confusion I found. Once there's a general understanding of what's going on and why it's going on, a lot of the mistakes are avoided. And effectively what this means from a policy standpoint is that the government accepts that owner-managers on a successful company may bonus out income or maybe salary out income where they're very profitable, and that's fine because they're going to pay tax on it. But they've limited the amount that will earn tax credits to roughly $275,000 a year, which I guess Parliament feels is realistic. Now, in the case of Mr. Castengay, his income being claimed every year was in excess of $1 million. And when they looked at the legislation, the judge really found that there was nothing to suggest that Mr. Castonguay's wages were anything other than salary and wages for the research that he did. He wasn't a commission employee. He didn't help with sales. He really helped drive the research of the company and was rewarded in some way by the overall sales. But his involvement on that sales was to create better products and to come up with better inventions. So this was, in my view, a very interesting ruling, and the courts are willing to entertain the fact that the law provides no limit on wages of specified employees as long as they're reasonable. And in the case of an arm's length employee with the skills of Mr. Castonguay, that was deemed to be the case. And that there's very little abuse here since specified employees are caught by those annual limits. So Parliament, I guess, has found that payment of specified employees' wages up to the $275,000 is within the spirit of the legislation.